Hi, this is Megan McClung, attorney with the Moran Center's School-Based Civil Legal Clinic. This month, we have initiated a new project called ERASE, which stands for Enhanced Record and Seal Evictions. The project aims to help Evanston renters take advantage of a new Illinois law that allows prior evictions to be removed from their records, making it easier to rent again. The goal of this project and the goal of this presentation for our Moran Center volunteers is to prepare for the eviction sealing month at the Moran Center. We will update you on the new sealing law that expires in August 2022. And we will also highlight what services the ERASE project will provide to Evanston residents. We'll discuss the requirements to qualify for an eviction sealing, and we'll review the process to seal an eviction. So why is October eviction sealing month at the Moran Center? We are celebrating our 40th year, and the Moran Center is highlighting the school-based civil legal clinic for the month of October. Because of that, we are opening up our legal services to the entire Evanston community for helping erase their evictions. Every Tuesday from 1 to 3 p.m. at the Moran Center, we're located at 1900 Dempster at the corner of Dodge. We have staff and volunteers who will be available to assist any Evanston resident who drops in. We will represent Evanston residents who are eligible for our free legal services throughout their entire sealing proceedings. Those who aren't eligible for our services can still come to us, and we will help prepare the necessary court documents to file on their own, and that they can represent themselves in sealing the proceedings. After October, we will continue to offer the sealing assistance to all School District 65 families. Until August of 2022, a new law is on our books that has expanded the eligibility for sealing evictions. In a little bit, I will talk more about the current law and the new law. The ERASE project is our way to help spread the word of the Moran Center's legal services for low-income District 65 families. Evictions, in general, can make it more difficult for any Evanston resident to find future housing. It lowers their credit report rating, and it can make them difficult for getting other loans or opening credit cards. When an Evanston resident comes to the ERASE Project Clinic, which you are welcome to volunteer for, those who are volunteering for it should look for the following information. And for those volunteers who sign up to take a case, what you'll want to look for on a follow-up with the client is, number one, their eviction court record. It is very important for us to try and get the past documents, any information or evidence about the judgment in their eviction, such as, was their case dismissed? Was there even a judgment? Were they even served in the proceeding? Any information about the outcome. Was there an order of possession? Was there an agreement to pay back the rent? Did the tenant comply with the terms of that last final order? When it comes to finding a case, it can be done online through the clerk's website or by going to the Skokie Courthouse and looking up the case at the clerk's office. So who qualifies for our legal services for this project? Right now in October, any Evanston resident. There is a caveat, and that is we will represent Evanston residents who are low income and eligible for free legal services so that we can file a legal aid fee waiver. And after October, we will continue to offer this free legal assistance to all eligible School District 65 families. For any Evanston resident who comes to our clinic and they're over income, they're still eligible for our services. We will assist them with preparing the necessary court documents only. They'll have to file on their own and represent themselves in sealing the proceedings. It's important to note that anybody who comes to the clinic with a current eviction will not qualify for our service. This is only for past evictions. And if someone doesn't qualify for our services because they're a non-resident or they're currently going through an eviction proceeding, we can refer them for assistance from the Cook County's ERP program, which stands for Early Resolution Project. It includes free legal aid, mediation services, and connections to other resources. You can visit the Cook County Legal Aid for Housing and Debt website or direct them to call the phone number on this screen, 855-956-5763. Eviction cases can be sealed. So what does this mean for our clients? This means that the eviction case will be suppressed from public view. Credit reporting agencies, however, troll the eviction filings and will continue to report the eviction even if the case is dismissed or sealed. That means that once an eviction sealing order is obtained, once we're able to confirm that it's erased from the court clerk's record, we must instruct the client or help them send a letter to the 3 major credit reporting companies and demand the removal from their report and send the sealing order with that demand. Now, how does this new law change the requirements for sealing evictions? Let's take a look at the old law here on the right. In the old law, you had to show that there is no basis in fact or law. It is in the interest of justice, and that those interests are not outweighed by the public's interest in the record. In prior eviction sealing motions, we would have to show all 3 of those requirements, not just one. And it's a very strict standard. And so it really meant that there was no reason the eviction should have been filed in the first place. The new law here on the left does state that it's for evictions that were filed during the pandemic between March 9th, 2020 and March 31st, 2022, and that they're eligible to seal a residential eviction until August 1st, 2022. In a little bit, I will explain why we will be filing these motions for any eviction that has been filed. So under the new law, it is now expanded to help people file an eviction if, again, the interests of justice in sealing the court file outweigh the public interest, the parties agree to seal the court file, there is no material violation of the terms of the tenancy, or the case was dismissed with or without prejudice. We'll go over those in a little bit more detail. How to seal an eviction. The way to seal an eviction is to gather all the information we can from the client, the case number, what happened, the hardships that they have faced since then, and then prepare a motion and possibly an affidavit. Motioning to seal an eviction. So today, many judges, even though the law is applicable to the COVID time period, we are finding that many judges in our circuit and other circuits are sealing any eviction case, even if it was filed before the pandemic. And so because of that, we are advising all Evanston residents to try and seal their case now under this expanded law, which will expire in August. And so it's very important that they take advantage of this now. It's important to know the basis for a motion to seal and to know that to present it to the judge. The first one, which is fairly straightforward, is that the eviction was dismissed. If the case was filed and an order was entered dismissing it, that is enough to file a motion to seal. If the case was dismissed with a judgment or an order of possession, then the question is, did the tenant comply? If they moved out of the home, we just need to attach an affidavit saying they moved out on the date in the order. If there was a judgment, we either need to file an affidavit from the tenant, or better, obtain a release and satisfaction from the landlord. There are form orders on the Cook County's website, a release and satisfaction showing that there was just a judgment entered on a date certain and that that judgment was paid. It needs to be signed off by the landlord or the landlord's attorney. And with that, that can be enough to move, to file, and get an eviction sealed. Another way to get an eviction sealed is simply if the landlord agrees. If the tenant complied with the terms of the last order and the landlord just simply agrees to our motion and we can show that, then we can move to have it sealed. The catch-all is if there are special circumstances to the eviction and it would be in the interest of justice to seal the eviction. So for example, if the tenant has had difficulty in the last couple of years trying to get another unit and say they've been living with another family member for quite some time, that could be enough to say it's in the interest of justice for this family to be able to find a tenancy now. We saw it in one case. I do have an example of where a mom and her daughter were evicted. They've been living with grandpa the whole time. They've been living in a 2-bedroom apartment. It's not enough room for their family. There were kids in the family too. And it was enough to convince the judge that there was a hardship at the time. She was actually going through cancer treatment and she lost her job. And that's why she fell behind on rent. And with all those terms, it was we were able to convince the judge that she should be able to have this erased from her record now so that she can get a new place. Another catch-all under the new law is if there is no material violation. I've seen another case where this was an owner-occupied rental and the owner asked the basement tenant to move out and the tenant complied. But the owner, not really knowing better, still filed an eviction to allegedly protect themselves in the future. They filed the eviction, nothing was done, it was dismissed. And so what we argued was that there was no material violation because they moved out when the landlord asked. If you obtain a sealing order for your client, the next steps are to file it with the clerk, to mail it to the 3 major credit reporting agencies, demanding that they remove and update your client's record, and then check the public record, the court clerk's file, to see if it's erased. It could take anywhere from a day to 6 weeks until it's physically removed from the court system. And then advise the client to keep a copy of the sealing record for their files, because once the record's sealed, we're not able to get a copy of the court order again. Now, what to do if the motion is denied? We can still advise our clients to send a release and satisfaction of the judgment, if we obtained one, to the credit reporting agencies. That could be enough to at least remove a judgment, if not removing the order of possession. And advise that the credit reporting agencies typically look at the last 7 years of somebody's history. And so an eviction that's over 7 years old most likely will not show up on their credit report. And a practical tip to share with our low-income clients is that if they seek housing that is owner-occupied rentals, they're more likely to get an offer of a rental agreement with an eviction on their record. Thank you for listening to this presentation on how we can assist Evanston residents in sealing their evictions now and continuing to seal them after the month of October. This is the flyer that we are pushing out on our social media, inviting the residents to come to our clinic 1 to 3 p.m. on Tuesdays in October. If you would like to volunteer during that time, please email me. And thank you again for volunteering your time and your talent for the Moran Center School-Based Civil Legal Clinic and our Erase project this month. Thank you.